These companies paid $31.5 million for misclassifying employees. Assistant store managers at Marshalls and Home Goods were promoted with salary increases, but continued performing the same duties: stocking shelves, folding clothes, unpacking boxes, cleaning stores, and manning registers, not the management and/or supervision of other employees or store operations. The company classified them as exempt managers to avoid overtime pay. The class action settlement, $31.5 million. There's a similar pattern at Burlington, where assistant managers spend most of their time on non-managerial tasks, such duties including working on the sales floor, stocking shelves, cleaning bathrooms, and more. Hey, my name is Alex Castro. I'm a labor and employment attorney with AXC Legal based out of South Florida. Everything that we're going to talk about today is not legal advice. So if anything here sounds familiar or sounds like an issue that you're dealing with, make sure you consult with a qualified employment attorney to discuss your situation and how it should play out in your situation. Yeah, that's a big one. And assistant store managers, more than probably any job title that I see out there, are so often misclassified. So the nature of exempt, classified as exempt versus non-exempt, is about, there's a lot of different variations on it, but for the most part, it's about, is somebody managing a team, a department? Are they making, significant decisions? Are they using independent judgment? Or are they just kind of doing the same work that everybody else does, kind of the grunt work of the team that they supervise? And the Department of Labor and courts have a lot of different tests for different exemptions for overtime classifications. Something about retail environments and assistant store managers often lends itself to there, because assistant store managers, yeah, they're one step above the individual people who are the clerks, the stock boys, whoever we might be talking about, but they're often not so much higher that they're not just doing more or less the same work of their team. So what a lot of companies end up doing is like, well, they're a manager, right? So they're exempt, and I can save my overtime costs on them. But that's not really what these tests look like. These tests are all about real life duties. They're not about job titles. Assistant store managers, like a lot of first level managers, are often doing the same type of work of their team. And if that's what you're doing, you're almost certainly not going to be validly classified as exempt. The thing about classification cases is that they're rarely ever black and white though. So here we've got assistant store managers who quite legitimately probably were doing tasks that were exempt. Maybe they're making schedules, maybe they are having one-on-ones with team members, maybe they're providing coaching and training and all that sort of stuff. But just because you do some exempt stuff doesn't necessarily mean that your entire employment becomes exempt, right? So Department of Labor and these courts implement rules that look at the actual reality of it. And sure, there may be like 10% of your day that you're doing exempt duties, but the other 90% you're not. And what makes these cases so damn expensive is that there are rarely ever decisions made for just like one person, especially in larger companies like this. They are usually systemic decisions. They're decisions that you make for an entire job class or for an entire location or facility. And your one decision has now impacted 10, 20, 50, 100, depends on your company, but you've impacted a lot of people, not just one person. So all the damages that you would owe for one person, now you've got to multiply that by however many people that decision affects, and that's going to be your exposure. There's a lot of judgment and a lot of gray area in making determinations about who's exempt and who's not. But to get you started, the Department of Labor has a ton of fact sheets online that you can just Google DOL fact sheet exemptions. And you're going to find, bulleted lists of what are the criteria that somebody needs to meet in order to meet the eligibility for that particular exemption that you're looking for. Give that a quick Google. 5 minutes of research is going to save you a ton of money, or wink, wink, click the link below. Anyway, these cases, they are crazy expensive. Whenever a company gets a classification case wrong, the damages that the Fair Labor Standards Act or whatever wage and hour law we're looking at in a state says that you've got to pay the amount of money that the employee would have earned for the time worked. So let's say because of your classification, they missed out on 5 hours of overtime pay every week. Multiply that by 2 or sometimes even 3, depending on the jurisdiction that we're in. Multiply that for every single week that this decision affected the employee by. Then you've got to add on your attorney's fees, which are easily going to be, minimum $10,000 in a really simple, quick case, and easily hundreds of thousands if this went into trial and beyond. So you've got a ton of different multipliers here and a lot of attorney's fees on here. And even for cases with just one employee who's misclassified, for 6 months to a year, which is not that much and pretty common, you're easily looking at a $50,000 minimum total legal bill after all is said and done. And that's just for one employee. So these cases, they scale on cost fast. And if anything that we've talked about today sounds like something you're struggling with or that you need some guidance with, lucky you, there's a link below where you can schedule a consultation with me.